It falls on me to similarly introduce a very, very distinguished panel. I think as far as the subject matter is concerned, I just want to help give you the statement that was in the announcement for this event, and the panel is going to help us unpack this statement. This is the question presented, if you will, for the panel, which is as follows. Is preemption being claimed to ensure consistent national marketing of critical medical devices and other healthcare goods? Or is preemption blocking access to justice for plaintiffs and thwarting innovation on the state and local level? There's a lot there, and what I'd like to do is give everyone here an opportunity on the panel to speak to the case, to give a preview, as Praveen has said, of the oral argument that will be taking place in December, discuss preemption doctrine, and discuss its application to FDA-regulated products, not just devices, but other products regulated by the agency. And what are the implications for health and safety generally? I mean, I think there's a lot here on law and a lot here on policy that we're very lucky to have this panel. So let me just go to it. We'll hear from each of these panelists individually, briefly, for 5 to 7 minutes or so. We'll have a discussion by the panel of the issues being raised by each of them. And then we'll open it up to the audience with press first for questions, and hopefully the discussion will get rolling from there. Let me introduce first, at the very end, David Frederick, who's a partner at Kellogg, Huber, Hansen, Todd, Evans, and Feigl. Feigl? Okay. David is a very distinguished litigator. He's argued numerous cases before the Supreme Court. He has one, as I understand it, in this term as well, that he's actually moving for very shortly. David is a recipient of the Coast Guard Medal for Distinguished Public Service. He's also a recipient of the Attorney General's Distinguished Service Award. He was an assistant to the Solicitor General in the Department of Justice from 1996 to 2001. And David also clerked for Justice White and the Honorable Joseph Snead on the Ninth Circuit, and as the author, if I understand correctly, of the amicus brief that was filed for this case. Is that correct?
Yes, for the AARP.
For the AARP. To David's right is Richard Samp, who is Chief Counsel for the Washington Legal Foundation. Richard has been deeply involved for many years in WLF's activity in Washington and abroad and across the country in litigation relating to individual rights, free enterprise, and government regulation. He was the lead counsel in the landmark case WLF v. Friedman, which struck down the FDAMA provision, 1997 provision relating to off-label promotion, which I personally actually was involved in helping to craft. No sour grapes here. But Richard is actively involved in litigation of preemption claims and liability cases, both here in Washington and around the country. And before joining WLF in 1989, he was a litigator at Shaw Pittman. To Richard's right is Catherine Sharkey, professor at the New York University School of Law. Professor Sharkey is a noted expert in torts, punitive damage, and class action issues. Before joining the NYU faculty, she taught at Columbia, and for many years was a member of that faculty. Professor Sharkey is a former Rhodes Scholar. She clerked for Justice Souter as well as for Judge Calabresi on the Second Circuit. And Professor Sharkey also has worked in the real world at Mayor Brown before she entered academia. I would also note, for the record, besides her many academic achievements and accomplishments, she was a member of the U.S. national team, lacrosse, and was an All-American player as captain of her university's team.
You did some Googling.
Yeah, no, it's all here, so we'll keep pointed objects and balls. And to Catherine's right is my former professor, Professor David Vladeck from Georgetown University Law Center. Before joining the faculty at Georgetown, Professor Vladeck was the director of the Public Citizen Litigation Group. He served for many years in advocacy and working in litigation involving consumer rights, government regulation, a broad range of issues that are pertinent not only to Washington but to health and safety across the country. He's currently a scholar with the Center for Progressive Regulation and is a member of the Administrative Conference of the U.S. You're teaching in clinic?
Yes.
As well as coursework, and is working today with the, let me see if I get this right, the O'Neill Institute for National and Global Health Law, which was recently launched at Georgetown and is an exciting center for research and study in that area. Let me just try to get out of everybody's way. I'm going to give you a brief recitation of the facts of the case, allow the panelists to really get into the meat and potatoes of the issues. But let me just cite these, round these off, and then open it up. We'll actually start with David Frederick. and then work her way across the panel towards me. But let me give you these case facts very briefly. In May of 1996, Charles, and by the way, this is subject to amendment, annotation, correction by the panel, who obviously have been thinking about this more deeply than I. In May of 1996, Charles Riegel was suffering from coronary artery disease, and he underwent a routine angioplasty to dilate his coronary artery. His physician used the evergreen balloon catheter, which was manufactured by Medtronic. During the course of the procedure, the catheter burst. Mr. Riegel's heart was obstructed. He was rendered unconscious and rushed to the emergency room for emergency coronary bypass surgery. As a consequence of the surgery, Mr. Riegel survived, but he survived with severe disability. As a consequence of this event, the Riegels sued Medtronic in the Northern District of New York. They alleged negligence in design, manufacture, and labeling. They alleged claims in relation to strict liability and expressed and implied warranty claims against Medtronic. In the district court, Medtronic argued that these claims were preempted by Section 521 of the Federal Food, Drug, and Cosmetic Act, otherwise known as Section 360K, if that's right, of the U.S. Code. This was a piece of the Food, Drug, and Cosmetic Act that was enacted a generation earlier as part of the Medical Device Amendments. As a consequence of these assertions, in March of 2002, the district court granted summary judgment, in part, I believe, on all but two of the claims, and following discovery, subsequently granted summary judgment against the two remaining claims. The Riegels appealed with respect to preemption, and in a 2-to-1 decision, the Second Circuit affirmed the district court on the grounds that the requirements under the Food, Drug, and Cosmetic Act for the regulation and approval of medical devices under the pre-market approval pathway, the PMA pathway, preempted the claims that the Riegels had made as being sufficiently device-specific. And they also suggested in the opinion, and please correct me if I'm wrong, that they considered it impossible for manufacturers to reconcile their obligations under state tort claims and jury verdicts with their FDA or federal requirements under the Food, Drug, Cosmetic Act. I would add as a side note that in 2004, Mr. Riegel passed away, and the claims are being currently pursued by his estate and his wife, Donna Riegel. So I'd like to take these facts and leave them open to the panelists to give you a grounding not only in terms of the importance of the assertion of preemption in this specific case, but also what we would anticipate before the Supreme Court in the immediate future, what kinds of implications this has for regulation of health and safety by the FDA, and what this suggests about the possibility of congressional intervention, if any, in this field, given the Supreme Court's actions and potential actions in this area in the immediate future. So without further ado, I'd like to leave this open to David Frederick for his initial presentation.
Thank you very much. I want to start kind of a different point, and that's the notion that manufacturers have a duty to use due care. We, as a society in the 19th century, began this legal odyssey over whether when a manufacturer made a product that somebody bought, there was privity of contract. And if there had not been some direct relation and direct chain, a person who was injured by that product couldn't bring an action. And so over the course of the late 19th into the early 20th century, the origins of a concept of the duty to use due care emerged. And I was reminded of this about a year ago when I was arguing a railroad case involving some victims of a train derailment in Minot, North Dakota, in which the train derailed, dropped a bunch of asphyxiating gas, killed a bunch of people, injured thousands more. And the judge at the argument asked me, well, I don't see anywhere in the Federal Rail Safety Act where this statute gives these people a right of action. Where are you getting that, counsel? And I said, well, I think, Your Honor, that for at least 150 years now, most jurisdictions have recognized the principle that there's a duty to use due care, and that if you introduce a product into the stream or you are engaged in some kind of transportation and you do somebody else wrong from your lack of due care, you are liable to that person in tort. And he said, yes, but I don't see how you get that out of the Federal Rail Safety Act. And I said, it doesn't come from the Federal Rail Safety Act. It comes from the common law. And what we have in this case is another manifestation of that basic tension between a common law principle or common law remedies that most states recognize either through judge-made law that's evolved over 150 or so years, and federal statutory regulatory principles that essentially provide a certain rules of the road for manufacturers that want to engage in the manufacture of products. In this particular case, and the statute that gives rise to the preemption puzzle that we're going to be talking about today, originated in the mid-1970s as a direct response to manufacturers that had products for medical devices that were out on the market and that had not been subject to any particular federal regulation. The Dalcon Shield problem, which some of you may have heard of, probably ancient history for those who are younger than me, was a particularly pronounced problem where the federal government had not engaged in any kind of serious look at that product before it went on the market. And Congress addressed the problem, as it did in a number of other consumer product areas in the 1970s, by trying to impose some requirements that would lead to a higher quality, higher standardization, greater safety for the consuming public. And what Congress did in the medical device amendments of 1976 was it provided for an express preemption in which no state or political subdivision was going to be permitted to establish or continue in effect with respect to a device any requirement which is different from or in addition to any requirement imposed by that's applicable to the device from the statute, or which relates to the safety or effectiveness of the device. And the way this language is actually paralleled in quite a number of statutes from the 1970s as a compromise between what industry was attempting to accomplish by having something that would be standardized at some level and the interests that states had in trying to continue to fill the gaps, if you will, of the absence of any federal regulation. But then what happened over the course of the 70s and 80s and 90s was that these preemption provisions in effect became the legal clarion call for the tort reform movement. And so manufacturers began to seize on these clauses as a way to argue that common law remedies that traditionally had been afforded to injured parties could no longer be brought because the federal standards that were in place through these statutes preempted them. And the basic argument was, and continues to be, as we'll see in this case, that if you are subject to tort liability for a jury action that holds you liable for damages because of a defect in your product or a defect in its design, that is a requirement that is different from what the federal agency had approved. And so they've taken the language of this preemption provision and particularly seized on the word requirements and persuaded courts, and the Supreme Court itself has had an interesting odyssey with respect to the meaning of that word in different statutes, to say that it applies to federal common law remedies, those impose requirements, and that if that jury verdict would be different from or in addition to what the federal agency had promulgated, that would run afoul of this express preemption provision. So what we have in this case is a challenge by the Riegels to the design, manufacturing, marketing, labeling of this particular product. And the argument that the manufacturer has made is that any liability that it would sustain through a jury verdict would be different from or in addition to the standards that the FDA would have applied when it gave pre-market approval for this particular product. And I think that like other and similar cases that have been litigated recently in the Supreme Court, such as Bates versus Dow AgroSciences, Spreetsma, cases involving railroads and automobile manufacturers, you've got preemption in the context of what did Congress mean in this particular statute and how extensively does the federal agency in fact regulate in this particular area. But you've got statutory language that from the 70s, the Congress, in a sense, mirrored and adopted, so that the language in this particular preemption provision is actually very similar to the preemption provision in the Federal Insecticide, Fungicide, and Rodenticide Act, which Congress had adopted a few years before. And it's also very similar to the Federal Boat Safety Act and other provisions that have this in addition to or different from language. And so the case ultimately is going to turn on what the court thinks is the preemptive scope and power of Congress's intent with respect to this pre-market approval of this particular product. Now, it's important, I think, to at least sketch a little bit of what we're talking about here in terms of device and what we're talking about in terms of pre-market approval. The FDA classifies different devices according to their level of dangerousness, and a Class 3 device, which is at issue in this case, is the kind of device that is particularly important for the life of a person or could pose the person potential risks and dangers. And by that classification, the FDA requires that if you're going to market it, you've got to get a certain approval at a level by the FDA. And I'm simplifying a lot for purposes of just keeping the discussion going, but the basic idea is that the manufacturer has to assure that the device is basically safe and effective, and that the labeling that it proposes to put on the device is neither false nor misleading, and that if there becomes available to the manufacturer supplemental information or slight modifications to the device, it's got to run that information through to the FDA as well. So what the manufacturer on the one hand argues is, hey, I got the FDA to okay that I can sell this device, and I got the FDA to basically approve this is safe and effective for its intended use, and I got the FDA to basically approve the label. You can't sue me claiming that I didn't live up to the obligations that the FDA has already approved for me. Now, the catch and the rub here, and what we argued in our brief on behalf of the American Association of Retired Persons and a number of other consumer groups, is that that kind of argument greatly overstates what the FDA, in fact, does in this particular area. The pre-market approval, in our assessment of it, really provides a limited screening that's inadequate, and it's not really intended to replace the normal tort remedies that traditionally are permitted to persons who are injured by defective products. And that the tort system provides remedies and incentives that are necessary to protect the public. Nothing in the medical device amendments provides for compensation if you're injured. Nothing in the MDA provides for specific incentives if the manufacturer doesn't quite do everything that looks like it needs to be done. And that the private remedy system created by our traditional tort system creates those kinds of incentives so that in addition to the regulatory perspective that the FDA brings to bear, there is a means for persons who are injured to obtain a remedy. It might be, for instance, that there is only one catheter that was defectively made, and that happened to have been purchased by the Riegels, and disaster happened when it was implanted. Under the manufacturer's theory, no remedy could ever be given to the Riegels, and there is none available under the statute, for that defect. And what the Riegels, in a sense, argue is that if there is a problem, even if it's just with one device, the normal tort system allows for a remedy to be given if a jury finds a lack of due care and damages and the other elements of the requisite causes of action. And so what we argued in our brief, and I think are kind of emblematic of the basic debate that is going on here, is that the federal agency has a role, and it's a very important role, but its role is not so all-encompassing and expansive that it should swallow up the traditional remedies that have been afforded to persons who are injured by defects in products. And the point is that by creating incentives and additional remedies manufacturers are, in a sense, safeguarding what they do even more. If they know that they might be liable for a defect in their product, or if there might be some warning that isn't quite good enough to ensure that the person would be put on notice of a particular problem, then they should be held liable for that, and they should pay damages and remedy the harm that they caused through their product. That's the basic pitch on one side. On the other side, the manufacturer essentially is saying, I can't engage in commerce in our very complicated national system if I've got to respond to the impulses and incentives created by 50 different state legal regimes. And so where the clash for preemption essentially occurs is in that rub. Where the court resolved that a couple of terms ago in the Bates case was to say that for things like how you label your product, what information you provide, all that the statute says is that you've got to tell the truth. And if the basis of the state claim is you aren't telling the truth, there's no reason why the state law can't serve as a supplemental remedy in the absence of any remedy given in the federal regime. It will be interesting, I think, to see how those kinds of arguments play out in this particular setting. About 10 years ago, the court heard argument in a case called Medtronic versus Lohr, in which it looked at the substantial equivalent provision of the medical device amendments and whether or not a device that was going to be introduced in the market was substantially equivalent to something that had already been approved. This case was sort of specifically carved out, or this situation was specifically carved out in that case, and after 10 years of litigation in which the courts have conflicted on the meaning of this preemption provision, we're now back up here in the Supreme Court. And with that, I'll pass it along.
I was asked by a reporter the other day, how could I, as a Federalist, support federal preemption of state regulation? In responding, I decided to overlook the fact that I really don't know what a Federalist is or whether I am one. And instead I told him that I've only rarely heard preemption debated seriously as a federalism issue. By that I mean few people argue as a matter of principle over whether the Founding Fathers would have wanted regulation over a commercial activity to be concentrated at the national level or the state level. Rather, it is well accepted that the federal government, by virtue of the Supremacy Clause, possesses the power to prohibit states from exercising authority over the types of issues we are discussing. The only questions worth considering are, 1, has Congress in fact manifested an intent to exercise exclusive authority over a commercial activity? And 2, as a matter of policy, is the general welfare better served by adopting uniform national regulation? I am here today to answer those questions yes and yes, at least with respect to the issues raised by the Riegel case, the design and labeling of Class 3 medical devices that have entered the marketplace pursuant to FDA's rigorous pre-market approval, or PMA, process. I plan to focus primarily on the first issue. What has Congress intended with respect to preemption of common law suits against the manufacturers of such devices? And relatedly, how do we go about discerning that intent? The Supreme Court has repeatedly made clear that it is congressional intent that is the, quote, touchstone, end quote, of any preemption analysis. But discerning that intent is often not easy, and as this panel attests, there is considerable disagreement regarding how we should go about that task. By way of background, the Supreme Court has divided its preemption analysis into two basic groups: express preemption and implied preemption. The Riegel case is usually grouped as an express preemption case because there is a federal statute, Section 360K, that expressly preempts some types of state regulation of medical devices. Such express preemption cases would seem to be relatively straightforward. When Congress adopts a statute that expressly bars state regulation of certain activities, it is up to the court to figure out just how broadly Congress intended the statute to apply. But that turns out never to be an easy task. The issue that arises most often is, does the preemption statute apply to state common law suits? The federal statutes never say explicitly one way or the other. Rather, the language will be something like, quote, all requirements, end quote, of a certain type are preempted. And so the question becomes, did Congress intend to include within the term requirements state court judgments that have the effect of imposing common law duties on the defendant? Most of the time, the Supreme Court has answered that question by determining that, yes, Congress intended to preempt at least some common law causes of action. But that answer is by no means self-evident in most cases, and some justices, particularly Justice Ruth Bader Ginsburg, have never reconciled themselves to that line of decision and would hold that Congress should never be understood to have intended to preempt common law suits unless it says so explicitly. The uncertainty is exacerbated with respect to preemption of state regulation of medical devices because the only previous occasion on which the court considered Section 360K in the 1995 case of Medtronic v. Lohr, it issued a particularly splintered 4-1-4 decision with Justice Breyer as the swing vote. 4 justices said that Section 360K virtually never should be read to preempt state common law suits. 4 justices said precisely the opposite, and Justice Breyer said that he thought that many such causes of action probably are preempted, just not the ones that were before the court in Lohr. Since then, 2 justices who favored 360K preemption, Rehnquist and O'Connor, have left the court. If their views are shared by Justice Alito and the Chief Justice, then Justice Breyer may again cast the deciding vote. Because Lohr was so badly fractured, I think it is fair to conclude that it will not provide the court with any clear guidance in deciding the Riegel case. Section 360K is a complex statute, so time does not permit a full explanation of why I think it should be interpreted as a bar to some of the Riegel's causes of action. Briefly, Section 360K bars states from imposing any, quote, requirements with respect to a medical device that are different from, quote, requirements imposed on the device by FDA. There is considerable dispute regarding whether this case involves the type of FDA requirements and the type of state requirements that Congress had in mind when it adopted Section 360K as part of the medical device amendments in 1976. From my perspective, I have little doubt that FDA imposes the type of federal requirements that 360K had in mind when, after approving a PMA, FDA requires the medical device manufacturer to design and label the device in the precise manner specified in the PMA. The closer question is whether a judgment arising from a common law cause of action meets the statute's definition of a state requirement. It is true that when Congress adopted the MDA in 1976, it appears not to have given any thought one way or the other to whether it was preempting common law causes of action. On the other hand, it's reasonable to assume that when it adopted Section 360K, Congress intended to preempt any actions by states that might undermine the FDA's regulatory scheme, even if those state actions took the form of lawsuits. But if, as I have just done, one focuses on potential conflict between federal and state regulation, one begins to blur the distinction between express preemption analysis and implied conflict preemption analysis. The latter is a branch of preemption analysis that focuses not on the words of a specific preemption statute, but on whether the state regulation at issue conflicts with federal regulation because it, quote, stands as an obstacle to the accomplishment and execution of the full purposes and objectives of Congress, end quote. And in fact, the brief I submitted to the court on behalf of the Washington Legal Foundation argues that the decision below can be upheld either on the basis of the Second Circuit's express preemption analysis under Section 360K or on the basis of an implied conflict preemption. Medtronic in the United States, on the other hand, confined their briefs to arguing in favor of express preemption. I'll cut short my legal arguments at this point and instead make a few policy-based observations. A victory for medical device manufacturers in this suit will not leave patients without any remedies. No one argues that all of the Riegel's causes of action are preempted, just the ones that conflict with FDA's requirement that Medtronic design and label its product, a catheter, in accordance with precise FDA specifications. Thus, while the court below held that the design defect claim and the failure to warn claim were preempted, it allowed the Riegels to proceed on their claim that the catheter was negligently manufactured and that Medtronic breached an express warranty. So in the case that David hypothesized, if in fact the Riegels had been able to show that there was something wrong with this particular catheter, under the Second Circuit's analysis, the case would have been allowed to go forward. Moreover, the Riegels are free to seek recovery from their physician, who, the evidence showed in this case, used the Medtronic catheter in a manner that Medtronic had strictly warned against. I think the evidence is pretty clear that the catheter burst because it was inflated far more than the specifications said it ought to be inflated. Finally, it simply is not true that we are asking the court to interpret a 1976 law as stripping patients of rights they previously exercised, despite the fact that the 1976 law was intended by Congress to give increased rights to patients. By definition, the PMA medical devices at issue in Riegel did not exist in 1976. So even under our interpretation of Section 360K, the statute does not deprive patients of a right to sue that they could have exercised pre-1976. It is eminently reasonable to conclude that if FDA has approved the design of a device after completing the rigorous PMA review process and has not later rescinded that approval, and if the manufacturer makes the device in accordance with that FDA-approved and mandated design, by definition, the design is not defective, and it makes no sense to permit patients to bring design defect cases against the manufacturers of devices that are not, in fact, defective. Thank you.
Catherine? Thank you. First, apologies in advance for the strained nature of my voice. I want to begin by conceding that it's definitely the case that common law torts has been the traditional purview of the states. What makes this area interesting, and my comments will be framed with respect to thinking about preemption in medical devices as an example or illustration of preemption in products liability. What's very interesting is that Congress has intervened in a very piecemeal fashion, and David alluded to several of the statutes. They've intervened in a piecemeal fashion to regulate various products. So the Boat Safety Act was regulating recreational boats. The Motor Vehicle Safety Act is regulating various automobile design type issues. And here we're talking about the Federal Food, Drug, and Cosmetic Acts, which interestingly, right, is through the Medical Devices Amendment regulating medical devices, which is the subject of the Riegel case, but it also regulates drugs. And there's an interesting divide with respect to the provisions addressing medical devices versus drugs. So the Medical Devices Amendments Act contains an express preemption clause that David alluded to, and the provisions addressing drugs do not. One irony that I found, at least, is that most legal commentators, academics for certain, and even individuals entrenched in litigation battles where they're trying never to concede anything against interest, will make the observation that the regulation of drugs seems more stringent than the regulation of medical devices, and yet Congress gives the express preemption clause in the medical devices area, not in drugs. So there's what some have called a sort of regulatory mismatch. This leads to the second point, which to my mind is quite interesting in this area, at least of products liability preemption. The U.S. Supreme Court in 1992 decided a case called Chipalone, and that was really the launch of what I'll call the sort of rubric of more than half a dozen cases since that time where the Supreme Court has decided preemption cases relating specifically to products. And if there's one thing you can say for certain about that group of cases, which includes Buckman, Medtronic, Geyer, Freightliner, Spritzma, Bates, is that preemption analysis looks, at least at first glance, like an entire muddle, right? You could align these cases, and there are certain of these that I've mentioned. Medtronic is another medical devices case. For example, Bates had express preemption clauses. Others of them, like Geyer and Spritzma, were being decided under the rubric of implied preemption. Now, if it's true, as the Supreme Court has often said, that the touchstone of preemption analysis should be congressional intent, one might ask, given this history, given the fact that Congress passes a variety of these statutes, always using the words requirements, right, never specifying even, right, one might give them a certain amount of leniency the first time, right, when it's done in the, late 60s, early 70s, just to fill in a little bit on the interesting history of tort law that David gave us. Of course, between 1960 and 1980, there was an explosion, right, of expansive product liability law across all of the jurisdictions. Congress had opportunities, even after they initially enacted some of these statutes, to come back and amend, right, and be clear. Tell us expressly and clearly, do you mean, right, when you intervene in these piecemeal ways to say that we should regulate medical devices, we should regulate drugs in very specific manners, do you mean do you intend or do you mean to displace common law tort litigation? And they never answer that question. So for myself, I actually find preemption analysis to be incredibly intriguing academically, because I think it is not, no matter what the court would say or commentators say, it is not an issue at least of pure textual statutory analysis, because that just doesn't get you very far. And certainly there are other canons of statutory interpretation which we haven't mentioned yet, and I find interesting in the Riegel, when I've read through the briefs in the case, certain parties mention this, certain leave that as an aside, and I'll give my theory as to why that is. But there's a statutory canon in this area called the presumption against preemption, right? So if all else fails, if you're an equipoise, if you have no idea, right, looking at the language of the statute, what Congress intended, then tip the balance towards against preemption. Now, had you not studied this area, you might have thought, well, that will be a particularly effective canon of interpretation in the area of implied preemption, right, where at least there's an express preemption clause. Those of us who are textualists should look at the language and should try to parse it and find its best meaning. If you look at the court's analysis, actually, they usually apply the presumption against preemption in the express preemption cases, and it goes unrecognized or unemployed in the implied preemption cases. Moreover, you might think, if you're going to apply textual statutory analysis, that at least where there is a preemption clause, then always go ahead and both stop there and preempt. But of course, Congress has been tricky in that, for example, the National Motor Safety Act that was at issue in Geyer, they included a broad preemption provision and an equally broad savings provision, right? So on the one hand, they're intending go forward and preempt all of these conflicting state requirements. On the other hand, there's a clause saying nothing here should do anything to disturb underlying common law liability. So it's very, it's a difficult matter. I would put it this way. If I were a court, right, and were being asked to dutifully follow the Supreme Court's guidance in this area, I might be concerned. And when I look to the legal academic commentary and I'm told it's all a muddle, I wouldn't be much more encouraged. So for myself, I thought what's interesting then is to think about preemption not as this simple textual statutory interpretation question, and the reason it's a muddle and the reason that it engages really smart, lawyers, academics, most of whom are sort of well-intentioned in terms of trying to find what the true meaning of these statutes are, is because it really involves a multi-dimensional analysis that involves layers of legal and policy analysis. So, for example, you might begin with the statutory language and trying to come to terms with its meaning. And nothing that I'm going to say is to suggest that where Congress has been clear, you would override that, right? Congress, with the stroke of its pen, I don't think anyone here on the panel would disagree, with a stroke of the pen could be clear that it wanted to preempt common law litigation. And very few people would argue that it's going to overstepped. It's now a wide berth of power under Article I to do so. So the interesting questions to me become the ones that are subsidiary, so to speak, which are interesting and hard questions of regulatory policy, of federalism interests, and finally, of the level of deference to accord to relevant federal agency views. And I'm going to focus my remarks now, in the time that I have remaining, on the latter, because what I found when I looked at these products liability preemption cases, in every single one of the cases, right, that has otherwise been described as this muddle, save Bates, and Bates is an interesting outlier on this point, in every single case, the U.S. Supreme Court's underlying or a decision as to whether they preempt or don't preempt accords with the position that was argued to it by the relevant federal agency. So the FDA was the relevant federal agency in Medtronic, and Buckman, NHTSA, and Freightliner and Geyer, the Coast Guard and Spritzma. the EPA, whose views were not followed, argued to the court in Bates. Now, what's interesting to me about that is that the agencies over the course of the period in time argue in different directions. So the court has followed these views in the pro and anti-preemption direction. Moreover, in almost you could argue that this has been just a sort of political shifting, but at least one of the cases, Spreetsma, was a conservative administration, and the Coast Guard was arguing the anti-preemption position that the court ended up following there. Now, what's interesting again is the court doesn't mention much about its following of agencies' views, and to the extent it does, it's very cryptic. It never says that it's according Chevron deference to the agency's view. In some cases, like in Medtronic, it talks about that it's substantially informed by the agency, that it gives substantial weight. Interestingly, in some cases like Buckman, where it appears to be heavily influenced by the position argued by the SG representing the FDA, it doesn't mention in the main court opinion this influence, but if you read the SG's brief, it looks remarkably similar to the analysis that's adopted in the court's actual opinion. So it has had an effect. And so the interesting question that I've been trying to ask is this normatively a good thing? And if so, we should bring it out into the open a bit and talk about what type of deference the agencies should get here. So I guess to just recap, and then I will say one last point and conclude. To recap, it's, yes, we should look to Congress to answer preemption questions, but where Congress has punted, and I argue there's pretty strong evidence that Congress has punted on this key question about whether or not to displace underlying common law litigation, you have to ask yourself the question, to whom are they punting? And the usual answers are either courts or agencies. And so it becomes a kind of comparative institutional analysis, at least from my perspective, when you break down preemption into its underlying subsidiary questions. On things, for example, like on questions like regulatory policy questions, on this question that Paul outlined at the beginning, should we be regulating things at a national, uniform, centralized level or at a local level? These theoretically, right, we can all speculate, or we could all probably agree, the theoretical considerations that would argue in favor of one or the other. So, for example, if states are able to export their costs onto the other states, that might be one reason why we'd want to regulate at the national uniform level, where there's really strong interest in uniformity. On the other side, if there are strong interests in experimentation or maybe democratic accountability coming from doing things at the local level, we might do it there. What I find is that in the real world, it's hard, right? Because as my former colleague Tom Merrill has put it, and I'll paraphrase, he has a great quip about this, which is basically that one man's, exportation of cost is another man's healthy regional diversity. So the problem is we can argue ad infinitum on all of these issues, whether it's labeling of drugs or whether it's regulation of products, at what level we should regulate. But I think these things should be determined in a case-by-case matter based on empirical facts. And as between courts and agencies supplying these facts, I believe that agencies could do a better job. So what I think is that agencies should be asked, right, to answer this particular regulatory policy question, and then there should be a means for courts to take into account their view. So that's basically the way in which I think this should go. It's not an argument in favor of Chevron deference in acknowledgement of the fact that there are numerous questions that courts are resolving in these preemption questions, but it does allow for getting information into the court from the agencies. So I will end there.
Thanks, David.
Maybe it's because I'm getting older, but I think history does teach us a lot about both the medical device preemption issue that's before the court in Riegel and the broader question of what I now see is this administration's effort to achieve tort reform through preemption ordered by regulatory agencies, not in the course of rulemaking, but simply by administrative fiat. Richard, I think, put the question well. The question is, what did Congress intend when it enacted the medical device amendments back in 1976? And here I got to disagree with Catherine. There's no regulatory mismatch between the medical device provisions of the statute and the drug provisions. The drug provisions date back to 1906. If you trace the history of the Food, Drug, and Cosmetic Act, it goes back to 1906 and then to the Bureau of Chemistry when before there was the FDA, to the modern FDA in 1938. At no time has there ever been a preemption provision in that statute. And so prior to 1976, to the extent there was regulation, direct regulation of medical devices, It was regulation accomplished by the states. And some states had acted extensively to fill the void. California had extensive regulation on many medical devices. And so when Congress was enacting the medical device amendments in 1976, there was not a syllable uttered during the debates of that statute on preemption of tort claims. Congress was well aware of tort claims. That's how Congress was motivated to act to begin with. The debacle with the Dalkin Shield and other medical devices was revealed through litigation. Compensation was bestowed through litigation. Congress, there is not a hint in the legislative history of that statute that Congress intended to withdraw that remedy either for existing claims or claims that would arise in the future. What Congress was worried about was how to fit into the new federal scheme pre-existing state regulation. And so I disagree with Catherine. There's not a broad preemption provision in the medical device amendments. There's a narrow provision that tries to accommodate the going forward regulation of medical devices by the FDA with long-standing state regulations. And what the provision does is it says that to the extent the state has requirements different than the requirements that the FDA will impose going forward, those claims are preempted. But there was not a hint to suggest that Congress intended to wipe away state tort claims. Now, part of this, of course, depends in part also on the nature of the review that the FDA was going to be asked to do for medical devices. One thing that gets lost in this debate, and David alluded to it earlier, is there is an asymmetry in the degree of review. If you look at the medical device amendments, because of the difficulties with testing medical devices in humans, much more difficult than in testing drugs, medical devices are often approved on the basis of very small clinical trials. There's extensive litigation over the St. Jude Sill Zone heart valve, which has been implanted in about 36,000 people. That device was approved by the FDA on the basis of a test involving 20 human subjects. Could not happen with drugs. Could not happen. Drugs are tested in multiple clinical trials involving thousands of drugs. Yes, we've seen Vioxx, Avandia. We know that those clinical tests, too, are too small and of too short duration to detect problems that arise rarely or over long periods of time. But Congress did not simply apply the same rigorous preclinical testing requirements to medical devices as they did to drugs, because frankly, you couldn't ethically do that. And so if one takes a look at the history of the medical device amendments, passed well after the tort explosion that Catherine talks about, there is not a hint that Congress intended to roll back the protection that had brought this issue to Congress's Congress's attention in the first place. And for those lawyers out there who really want to test this proposition, go look at 360K. The fight in front of the Supreme Court is on 360KA, which is the preemption provision. But there's a B, part of the same provision of the law. And what B is, it's a provision to allow states that want to keep their stricter regulation of medical devices to apply to the FDA to get permission to do so. The word used in both provisions is requirement, which in my view drives home the fact that Congress, when it used the word requirement, had nothing to do with state tort law. It had everything to do with trying to mesh together pre-existing regulatory systems. So that is a FDA case that's going to be before the court. I don't make prognostications about how the court is going to rule. I would disagree mildly with Richard about Justice Breyer's opinion in Lohr. You can all go read it, and of course everybody is going to be hanging on every question Justice Breyer utters at the argument to see whether he's inclined to go one way or the other. I would like to note that there are two other FDA-related cases. One has been, review has been granted. The other, I suspect, may well be granted, in which case my former colleague Brian will be arguing this before the Supreme Court. The case that's been granted is Warner-Lamberth, which is a case that is very much like the Buckman case, or presents issues which raise the question of whether fraud on the FDA claims can be pursued before the Supreme Court. I don't want to go into that case. More interesting, and one way to get into the broader conversation, is Levine. Levine is a case out of the Supreme Court of Vermont, and it raises the question of whether there can be preemption of claims involving pharmaceutical products approved by the FDA. Drugs, not devices. There is no express preemption provision, even a limited one, in the drug provision. And we get to this case because although the FDA had consistently, throughout its history, always taken the position that there was no preemption in drug claims, the FDA has changed its mind. How do we know this? They started filing amicus briefs in 2002, taking the position that there was preemption, and in 2006 they published a Federal Register notice taking that position more formally, though they never engaged in a rulemaking to adopt that provision. This is a dramatic shift in policy. This statute has been on the books for in one form or another for 100 years. It's been revisited by Congress as recently as a month ago. It still contains no preemption provision. Because the lower courts are now split on many of the issues that my colleagues have raised, including whether the FDA's new position gets deference or not, I suspect that at some point soon the Supreme Court will have to sort that out. But I want to close by talking about the widespread assertion of preemption by this administration. The FDA is taking this position not just with respect to drugs, not just with respect to medical devices, but with products like sunscreen. There's a new rule on sunscreen products. The FDA now claims that they preempt whatever tort cases that might be brought. Women who are pregnant eating methylmercury, the FDA now takes the position that a guidance that it posted on its internet warning women who are pregnant not to eat large quantities of fish that have mercury, that claim is preempted too because the FDA posted a warning. Other agencies, the National Highway Traffic Safety Administration has also taken the position now in 7 rulemakings that its new rules preempt. And again, I want to address Catherine's claim that these are broad preemption provisions. I don't think they are. The National Highway Traffic Safety Act, the Safety Act, was passed in 1967, well after many states had begun to regulate. Is that me? had begun to regulate motor vehicles. And so if Congress is, as it was with the Food and Drug Act initially, regulating where there's no background rule, there's no need to address preemption. But when Congress is regulating in the face of extensive state regulation, Congress needs to specify exactly how state and federal law will be accommodated. And so you have the same kind of language in statutes like FIFRA, David Frederick's favorite statute, the Motor Vehicle Safety Act, which were enacted against a backdrop of extensive state regulation. And the NHTSA statute is especially problematic because it contains an express savings act that says nothing in this statute shall cut off tort remedy. Nonetheless, the agency now claims that every new rule it promulgates going forward will cut off tort claims. I could go on. You've seen this with the Consumer Product Safety Commission. You've seen this with the Federal Railroad Administration. This is preemption through fiat, and it raises very troubling questions, in my view, about the authority of agencies to engage in this kind of lawmaking. Because when the agencies claim that state causes of action are simply wiped off the books because of a one-line sentence in a Federal Register notice, the agency is asserting that that is true as a matter of law. This all will get sorted out over time in the courts, but it raises very troubling problems that we will, I think, start getting some answers on in the next couple of years. Anyway, thank you.
Thank you very much. These have been very, very helpful, very insightful presentations. And I'd love to open it up for any comments that you might have on each other's presentations and views. I do have some what I would describe as softball questions, since you have the answers and I don't, and I think it'd be helpful to have those questions answered, and then we'll, of course, open it up to press for questions as well. But does anyone want to have a rebuttal time or anything like that as far as additional insights?
I'd like to make a couple of comments. Catherine said that Bates was the outlier of the cases, and in the sense that it was the first time that the court had rejected the views expressed by the Solicitor General. I don't think that's quite right, but it's also important that the Solicitor General had authorized the position that I argued on behalf of the peanut farmers who were injured in that case. And so it was a reversal. I mean, it was a situation where Solicitor General Waxman had authorized the government to file an amicus brief in the courts of appeals that would argue for no preemption. And then Solicitor General Olson reversed that position in Bates to argue that the claims of the farmers should be preempted. And what the court, I think, has recognized is that there is becoming a heavily political component to the preemption analysis, and I would agree with you about that. But then even with respect to the Spreetsma position, that was one actually that had been formulated in the Clinton administration in the case of Lewis versus Brunswick. The case, I actually represented the United States in that case as an amicus supporting the injured person from the boat accident, and the case settled after the oral argument. Several years later, another case comes bubbling up, and the Bush administration Solicitor General's office, hewed to the position of the statute. I don't want to say that I think that there is, politics run amok or anything like that. I think these are very hard questions that do require an awful lot of analysis where honest people can have reasonable views that differ on this, and your perspective on how you interpret the statute is going to depend to some degree on the angle at which you're coming. But I do want to wholeheartedly endorse what David said, which is that the Bush administration has been so pro-preemption that I think it has shifted the analysis and the focus way out of equilibrium, and that there are very significant costs and risks to the system by having what in effect are non-politically accountable decisions by agencies through notice and comment notices or briefs filed in various courts, where the basic fulcrum of the balance between federal and state law is not one that's being made by our elected officials, but it is being made by agency regulators. And I guess, Catherine and I, having represented a lot of those agencies when I was in the Solicitor General's office, they vary in their degree of expertness. And so when we are allowing them to, wipe out remedies that are available to people who get injured on the basis of what are, in effect, a paucity of enforcement tools. I mean, let's look at what the FDA here can't subpoena information in these pre-market. It doesn't have the authority to conduct independent tests. They can't compare the safety and efficacy of a device for pre-market with something that's already on the market. I mean, what their tools are in allowing these devices to go on the market is actually relatively limited. And on the basis of taking submissions by industry, they're allowing these products to go forward. And David, you didn't even know this, but I appreciate you putting in a plug for my clients in the St. Jude case. I represent the class in that case.
Go see David if you need a good lawyer.
It's terribly troubling that you can have these devices that go on the market with relatively little real information that allows people to make an assessment of whether or not they're exposing themselves to substantial risks.
And we'll have a disclaimer crawl across the bottom of the screen in any subsequent replay here.
Can I?
Please, absolutely.
I have a few things to say in response. First, I mentioned Bates. Actually, I'm talking about a limited grouping that I've assessed of products liability preemption cases, and I gave the sample, and it is the outlier. And what I've developed in some writing is actually along the lines of what you've just suggested, which is, interestingly, the court seemed, although again, the court is never specific, the U.S. Supreme Court, about what level of deference it's according to the views, whether it matters that they've switched position. But when you read Bates, it looks like that was a factor. The fact that the court that the SG's office within a 5-year period had switched position, had argued the opposite position before the California Supreme Court, and the only explanation given in the brief was, well, the California Supreme Court disagreed with that position. So now we're taking the opposite, which doesn't seem. I mean, if I were to come up with reasons for my views on various things, whether one particular court adopted them or not, doesn't seem like the most powerful reason. And what I've actually said is applied to the Riegel case, this is potentially an interesting factor that hasn't been fully addressed, actually, I don't believe, in any of the briefing, maybe because the parties are trying to be very delicate about this issue of what level of deference to accord to the agency view, because, of course, the FDA has switched positions here on its view about whether or not the preemption provision should preempt in situations where there's been pre-market approval, exactly what's at issue with Riegel. And they took the opposite position in the late 90s, early 2000s, and in 2004 changed the position in the Horn brief. And the Solicitor General, in the brief to the court, to my mind, is trying to delicately address this issue by saying, of course, we have a reasoned view for why we've changed. But if you read the brief, it's a little thin with respect to what exactly has changed. Allegedly, something's changed with respect to the risk management that the FDA has been doing with drugs, and they cite to the provision from the FDA preamble on drugs, which is a little awkward because this is a medical devices cases, that there's a risk if you overwarn that might be a bad thing. So I actually am not sure that I was presenting sort of a position that's that different from what you just espoused. But second point I'd want to make is I've written also a paper called Preemption by Preamble, and I've been very skeptical of the Consumer Product Safety Commission, which for its first time in its over 30-year history had a preemption provision in a preamble dealing with mattress flammability. The NHTSA did this. FDA did it. My point is simply that if Congress isn't going to answer what I think is this multidimensional inquiry, we have to think seriously about comparative institutions, and I don't think courts are particularly accountable on these kinds of issues of regulatory policy or federalism issues. And I think there might be ways, if we devoted attention, that we could see whether agencies, through doing notice and comment rulemaking, through having various review provisions that made sure that states' views were responded to, as well as provisions that the court has begun to develop about if an agency is changing its position, what kind of reasoned policy analysis does it have to give. And the final point I just want to make isn't responsive, but was prompted by the earlier discussion about the importance of tort and remedies. And I just can't resist, because, of course, I teach torts, and it's a sort of passion of mine as well. And one interesting experiment, one that when I teach a seminar, I'll make my students do this, is look at these Supreme Court cases and tell me what the Supreme Court's view of tort is. And you will see that it wears the tort as two hats. In one hat, tort is all about remedy and compensation, and everything that David suggested makes a lot of sense. And in the other hat, tort is regulation, and damages regulate. Common law damages regulate exactly like federal regulations do. And the key is that's actually a really difficult question, and I'm not really sure when we're trying to answer nuanced questions that preemption raise about how federal regulation and common law tort dovetail, we can look to those kind of caricatures or stereotypes about what tort is all about when everyone who studied it seriously sees it in its various guises. And again, I'm not sure that I want to look to courts, particularly with this, the ease with which you can come to one absolute view or another and either preempt everything in sight or say tort is all about remedy, so nothing should be preempted. And by the way, a lot of lower courts take one of those polar opposite positions, and I think they're both wrong, actually. So as my now colleague Richard Epstein at NYU says, either I have the virtues of a view of moderation in an issue that splits, or there's some kind of murkiness going on in my thinking at the moment.
Richard, did you want to comment on that?
Yeah, I agree that there has been a lot of vacillation within federal agencies as to the meaning of these preemption provisions, and that's one reason perhaps to provide a certain amount of deference, but maybe not too much deference. And in particular, as I've heard people discuss the Levine case that David mentioned earlier, it's one that, if it does get granted cert, would likely be argued during the Bush administration. On the other hand, there would be good reasons for the court perhaps not to grant review because the issue is really percolating among the courts, and you might want to say, well, let's let the federal courts of appeals that are considering this issue right now consider the case before it comes up. If you did that, however, very likely the case would not be heard until the 2009 term, at which point there might be a Democratic administration in power. And I think that there are people who, on the pharmaceutical industry, who would like to see the Levine case heard precisely because they are afraid that there will be, once again, a 180-degree shift in FDA's position on this issue if there is a Democratic administration starting in 2009. The other point I really want to quickly make is, while there has been some discussion here about how perhaps there isn't that much FDA review of PMA devices before they get onto the market. Perhaps you could always have an infinite number of human subjects tested before you gave approval, but I can tell you that in comparison to at least 95%, if not more, of all medical devices that are on the market, PMA devices really do get the full treatment. The devices that were at issue in the lower case were ones that were essentially grandfathered based on the fact that they either were on the market in 1976 or they were similar to devices on the market in 1976. And FDA went out of its way of saying, we never approved the design of these devices. We just said, okay, we have to let you on the market, but we're not saying anything about your design being good and safe and effective. There has been some major effort to say that the product is safe and effective if it has been approved under the PMA process, and you can argue that perhaps that's not enough to mandate preemption. The fact is there has been a very careful FDA look at the product. They have specifically endorsed the design that's in place, and in fact they tell the manufacturer you can't change that design without coming back to us and going through an extensive review process. So we're not really talking about preempting more than a very small percentage of the possible suits that are out there.
Yeah, let me just make two quick follow-up comments. First, on PMAs, device manufacturers change their devices routinely without letting the FDA know. If you go look at the history of the recalls of the guidant defibrillators, not only did they make significant changes in the defibrillators, they kept on selling the defective ones until litigation uncovered that problem. And finally, they told the FDA and started taking off the defective ones off the market. I want to respond to Catherine's point about Congress, because it's easy to scapegoat here and say Congress is the culprit. I don't think that's fair for two reasons. First is there are provisions where Congress does explicitly preempt tort law. They do not bear any resemblance to the provision at issue in Riegel. But Congress has at times decided to wipe away state tort law and has done so carefully and explicitly. You don't see that kind of language in any of the cases that we have before us today. The second is Congress is between a rock and a hard place. You talk to members of Congress and they say, what can we do? And the first thing is, well, you can put in a savings clause. Well, Congress is not happy with that with that option because the Supreme Court in Geyer, in the face of the savings clause, nonetheless found broad preemption. And so Congress, I think, is struggling with this issue. I think now that there's a different Congress, we are likely to see legislative efforts designed at trying to get at this problem both statute by statute, but also more generally. But these are very difficult problems for Congress to solve because the way that most lawyers would have suggested prior to Geyer, put in a savings clause, well, that didn't amount to a hill of beans in the Geyer litigation. And so I'm not sure it's so easy for Congress to solve this problem the way Catherine suggests.
In the process of these additional views, I've been crossing off these balls and softballs that I had in play, but I'd like, if possible now, to open up the session to questions from the audience, leading off with any press questions that may be available at this time. Please.
Just as a matter of handicapping the court, on the kind of threshold determination they made years ago when these modern preemption cases started, that requirement that state tort systems amounted to a requirement within the meaning of the preemption clauses. Is there a solid majority of votes for that today, or is that open to? Is that squishy? Where's the court today on that?
Can I take that?
Yeah.
Okay. I argued the Bates case for the peanut farmers, and our first argument was requirements does not include common law remedies. We pitched that because in Medtronic there appeared to be a 414 on that very question, and we thought that we had additional arguments to marshal that might persuade Justice Breyer to be a fifth vote on that question for us in Bates. We also thought that because the arguments were, in our view, sufficiently strong, that if we led with that argument, that our backup argument relating to whether or not addition to or different from would be sufficient to save a number of claims that we wanted the farmers to be able to bring against the pesticide maker. We got no votes for requirements is not common law. Justice Stevens, who had led that in Chip alone and had kind of explored that and had promoted that view in Medtronic, flipped over in the majority reasoning, and I think that that may have been one of the internal discussion points that led the Chief Justice Rehnquist and Justice O'Connor to join the other 5 in holding the bulk of the claims brought by the farmers not preempted against Dow AgroSciences. But I think the court there is pretty clear in saying, at least in FIFRA, and there's not really that much of a reason to think the other statutes using the word requirements ought to be interpreted differently for this point, does encompass common law claims. My own personal view is that I think that if you're looking at what Congress is really getting at, I think it was talking about positive enactments by state legislatures and state regulatory agencies. But I think after Bates, it's a very hard argument to make that that the court didn't seem to think that requirements also in most of these circumstances is going to include state tort suits and remedies.
So that's just basic preemption stare decisis at this point.
Well, it is. I wouldn't go that far. I would say that every statute is treated differently, and you look at how requirements is used in that statute. And we had a whole range of arguments for why under FIFRA we didn't think that requirements should be interpreted to extend to common law suits and go beyond state positive enactments. In that statutory scheme, the court did not find those arguments persuasive. That's not to say in other statutory schemes where Congress's use of the word requirements or the context of its use would not lead to a different result.
Just to follow up on that, I thought that the Bates court got the issue exactly right, and the decision really has been very, I think, powerful within lower courts. You see it cited all the time. The point that they made was, on the one hand, yes, common law suits can be requirements, but on the other hand, not every judgment imposes a requirement, but you have to look to what is the precise requirement being imposed, and simply because you lose a tort suit might cause you to stop marketing your product or might cause you to pay the judgment and keep marketing it. That by itself doesn't make it a requirement. Instead, you have to look cause of action by cause of action, what is the precise requirement being imposed? And I think you're going to see more and more courts going through 10 different causes of action and saying these 3 are preempted and these 7 are not, because they don't really impose a requirement in the sense that Bates meant.
Well, can I just follow up? So given that, swishing this case by case, given that, so why isn't the answer to this case or any case the kind of simple proposition that I read in one of the briefs that Tim Dowling filed for Community Rights Council, that given the presumption against preemption and all this, just require a plain statement rule, and if there's not one, there's no preemption. By requirement, we, the Congress, mean state tort judgments.
Well, I think that would be one response. I think the court is getting a little more wary about imposing plain statement requirements. But that would certainly be an out for the court. And let me just add one thought about requirements. I think the court has drained that word of any meaning at all. And the battle in every case is over the context surrounding requirements, what Congress intended the requirements really to mean. And so you have cases like Spreetsma and Bates where court is really, yes, I think they leave open the possibility that state tort judgments may impose requirements, but only in narrow circumstances. And so, yes, there's a lot of discussion about the word requirements, but I think it's simply a way for the court to discuss the broader questions about the context of the statute and what Congress really meant.
So just a quick some of the justices answered the precise question in Medtronic, of course, right? So some of the justices have changed since then, but just to be clear, right, the plurality there was very ambiguous because they have this line, I just found it in something that I've written, that 360K simply was not intended to preempt most, let alone all, general common law duties enforced by damages actions. This was Justices Stevens, Kennedy, Souter, and Ginsburg, all of whom are there. But they did go on to say, it's apparent that few, if any, common law duties have been preempted by this statute. It will be rare indeed for a court hearing a common law cause of action to do so. So they may have contemplated. Prior answered a clear yes in his concurrence, and then the dissent had answered a clear yes, and still on the court, of course, are Scalia and Thomas. So some of the justices are, I think, bound by their views in Medtronic because it was the very same preemption provision. My main point, though, on presumption against preemption, I mean, I think the court is seriously divided about the utility of the presumption against preemption in preemption analysis. And if it weren't, I mean, there have been some good empirical studies, both that show that through the whole course of hundreds of preemption cases beyond just these products liability ones, that basically the preemption decisions come out about 50-50. So it's hard to know that if there was a strong presumption against preemption at operation, what kind of work it's doing there. And also, if you look at these cases, the very fact that the court is bringing up the presumption where there's an express preemption clause, but where there's none and it's implied preemption in Spreetsma and Buckman, doesn't mention it whatsoever. You know, I thought that there's not so much attention as I thought there would be in the briefs. The SG's brief here in Riegel just has this argument that the presumption doesn't apply, but it didn't really explain exactly why the presumption doesn't apply in this particular context. So I'd be very surprised if the court, and you're right, it's an out, but I'd be very surprised if the court just said the presumption against preemption applies and we need a clear statement rule here, because I don't think they have a majority who believes that.
Question?
Yes.
Mm-hmm.
Okay, very good. First, a brief observation for Professor Sharkey, and then a question for Mr. Sam. The observation is on the question about what the courts should do with the shifting views of administrative agencies, and in particular FDA. The merits briefs in Riegel don't address that, but there was an extended discussion on the cert petition stage. One notable thing there, of course, is that the Supreme Court requested the views of the Solicitor General about whether to grant cert. The Solicitor General went off and, after many months, submitted a brief saying, nope, lower court got it right, do not grant cert, and 4 justices voted to grant cert anyway. So, the question for Mr. Samp. I was very taken at the merit stage brief by the petitioners here, the Riegels, that in applying the statute, you need to look separately at the federal requirements and the state requirements. The state requirements is all about, if a jury issues a verdict, is that a requirement imposed by a state or is it something else? And that's much of what Justice Breyer's concurrence in Medtronic v. Lohr addressed. But the separate issue, it seemed to me was argued quite persuasively, is that you need to discuss what is the alleged federal requirement. And in Medtronic v. Lohr, the court didn't seem to have any trouble finding 5 clear votes, at least, that the specifications for a medical device in a substantial equivalence context do not add up to a federal requirement of the sort that you even need to begin engaging the question about, is a state jury a state requirement at all? So if that's correct, the specifications, the level of detail about what a medical device looks like in the PMA context, as I understand it, is much the same as in the substantial equivalence context. Now, you're absolutely right when you say that the FDA gives much more scrutiny to a PMA application than it does to a substantial equivalence application. But in terms of the level of detail in the application, if the application in the substantial equivalence context does not add up to, you asked for permission to market a device with such and so, we're not going to give you, quote, approval, but we will give you authorization to market it. If that doesn't constitute a federal requirement, why is it that a similarly detailed PMA application does constitute a federal requirement?
Well, the Second Circuit had a lengthy analysis of that very question in its decision, and it said, frankly, we think there is a lot of conflicting language within Lohr, because you're right that in the portions of Lohr that were joined by Justice Breyer, there is language that suggests that the types of requirements that are also at issue here, the types of federal requirements, don't meet the specifications of Section 360K. On the other hand, Justice Breyer very clearly said that I do think that a lot of causes of action are preempted. So the Second Circuit came to the conclusion that he probably felt more strongly about those statements than he did in the statements of, I guess it was Justice Stevens, in the portions of the Lohr opinion that he joined, and they said, we really can't find that the concurring opinion and the plurality opinion are really the same on this issue, but we're just going to go with what Justice Breyer said in his separate opinion. And if he sticks with those portions of the Stevens opinion that he joined in Lohr, then you're right. There are 5 votes to say that these are not federal requirements. One of the interesting things here is that to say these aren't federal requirements, you really can't base that on the statute. What you really have to do is to go to the FDA regulations that have been around a long time, and those regulations, to the extent that there is an argument that these are not federal requirements, it's based on the regulations, because there is language in the regulations that seems to say that they have to be a FDA requirements that are device specific, even though that language is not in the statute. And so to a certain extent, you've got a position of, well, how much do you want to defer to FDA in this case? Because FDA, on the one hand, is very much in its brief on the side of Medtronic. On the other hand, the FDA regulations somewhat undercut the position that FDA is taking, and those regulations have never been rescinded. So you have a valid point.
I would say there are many sponsors who would be surprised if they were to hear that they were not subject to requirements under the 510K process, much less the PMA process. Any other questions from the audience? No. Well, if there's no objection from the audience, I'd like to thank the panelists for a very insightful session, and I hope that we'll be seeing them again shortly. Thank you so much.